Okay, let's begin. Welcome to the final seminar of the Electoral Regulation Research Network. My name is Joo-Cheong Tham, I'm the director of the network. The network, for those who don't know, is an initiative that's sponsored by the two main state electoral commissions in this country, the New South Wales Electoral Commission and the Victoria Electoral Commission, as well as this law school. And its key brief is really to provide a forum for robust discussion and debate on matters involving electoral regulation. And there's no doubt that today's topic is one of those controversial topics that falls within the, if you like, the portfolio of the network. When I was sort of organizing a seminar, I was thinking about who would be best to chair a seminar like this, given that I was going to be a commentator. And I thought that the name that came immediately to mind was Nick Reece. And Nick, my colleague and friend Nick, who is actually works in the interior heights of the Vice Chancellor's building now, isn't it? Yeah. Is a person who I think you might have seen columns that Nick has written in the press, in particular the Fairfax media. Nick is a person who actually brings a lot of intelligence, wisdom to very complex public policy issues. And a person who brings to bear that intelligence grounded in, I think, very deep experience in the political process. Nick has had various roles, including State Secretary of the Victorian branch of the ALP, and including being a senior advisor to the Prime Minister Julia Gillard when she was in office. So without further ado, I'm going to hand over to Nick, who's going to chair this seminar, and then we'll get the show on the road.
Thank you very much, Joo Chong, and great to see a good turnout here today for this event. Of course, it took me all of 2 nanoseconds to say yes to the very kind invitation from Joo Chong to chair today's discussion. My role is really just keep out of the way and make sure that our 2 speakers get to make the best contribution possible. I also want to encourage you to ask questions when that time arrives, and as chair I'll make sure that we get plenty of time for questions, and the feistier the better, and if the hard questions aren't being asked, then I'll be asking the hard questions. So I'm looking forward to a lively discussion and debate later on. We're very fortunate to have Keith Ewing visiting Australia at the moment, Professor Keith Ewing. Because the topic for today, trade union political funding, is obviously one that is very topical in this country. If you happen to have been living in a cave for the last 2 years, you might not know that there is currently a Royal Commission into trade union governance and corruption, chaired by former High Court Justice Dyson Heydon. And that commission has put a spotlight on political funds of trade unions, and in particular so-called slush funds. Many of you, I suspect, might not know that in the United Kingdom, a debate is also going on in this area because the Conservative Cameron government has introduced a bill that would replace the opt-out system in relation to trade union political levies with an opt-in system. So you need to proactively opt in if you want your trade union membership levy to go to political purposes. So developments in both countries do pose a very big question. How should the political funds of trade unions be regulated? Keith Ewing is going to be our first speaker, followed by Joo-Cheong Tham. Professor Ewing is Professor of Public Law at King's College in London. He has had a distinguished career, both in academia and in politics as well, I should know, working at the Universities of Edinburgh and at Cambridge. And he's also had many various visiting positions internationally, including here in Australia. He's also the president of the Institute of Employment Rights, a prominent think tank, and he's the vice president of the International Centre of Trade Union Rights. He's going to be speaking with us today on the question of and comparison of the Australian and UK situations, and we'll hear afterwards from Joo Chong, who I'll introduce in due course. So first, please make him welcome Professor Keith Ewing.
Thanks very much. Okay. If I stand here, can you hear? You hear the back okay? Yeah, okay. Okay, well, thanks very much, everybody, for coming. It's, I should say to those of you who don't know that there are probably 26 conscripts here from our LLM class, which is meeting this week. But so welcome to the conscripts and welcome to the volunteers as well. So it's nice to see you too. I'm going to speak about something which was the subject of my PhD thesis in 1976, and it's been following me around like a bad smell ever since. So I've been trying for most of my life to drop this subject, but every time I try, something pops up, and I feel obliged to re-engage. So I'm going to talk about trade union political funds. What I'm going to talk about is not perhaps what Dyson Heydon is talking about. So I'm not talking about so-called slush funds. I'm going to talk about the issue as it presents itself in the United Kingdom, but I think there may be aspects of our system that could be extended to other jurisdictions that might help provide solutions to problems in other jurisdictions. And I say that not with some humility, but I say it because I know, for example, the US Supreme Court has consciously adopted the British model in a case in 1961, which is very unusual for the American Supreme Court to adopt foreign legislation. And in this case, it actually appended the British legislation to the end of its decision. And the legislation I'm going to talk about was also adopted here at state level. There was in New South Wales, and I think Queensland and WA, but for some reason the legislation, I think, has fallen largely into disuse, and is probably wholly irrelevant now since the new structure of powers on employment matters between federal and state systems. So, but anyway, so it's a system of regulation that we have which has travelled quite well, I think, to other parts of the world. So the issue then, and just to give you some numbers, I mean, what I'm talking about a system whereby trade union members pay money into trade union political funds on an open, transparent, and voluntary basis. And at the moment, it's transparent in the sense that there is a public regulator who publishes information and data about this on an annual basis. Online, last report, he's called the Certification Officer for Trade Unions. And looking this morning, there are 26 trade unions with political funds. And in these 26 trade unions, we've got 4.9 million trade union members who pay a political levy. In these trade unions, about 0.6, about just over 500,000 don't pay a political levy for one reason or another. And between them, trade unions on an annual basis will raise £23 million for their, so just double that for dollars roughly, £23 million will be raised into political funds, of which last year 19 million was spent. And at the moment, they have combined reserves of about £29 million in their political funds. And the question then is, well, what is this money used for? And it's used principally for three purposes. One is to make affiliation payments to the Labour Party, in the case of those unions which are affiliated to the Labour Party. Secondly, it's to make other general donations to the party to help out from time to time with the business of the party. And thirdly, it's to make donations at election time to help fund election campaigns. And we have a system now of constant elections. If we don't have a general election, we've got a European election. If we don't have a European election, and we've got elections for the Scottish Parliament, the Welsh Assembly. If we don't have that, then we've got local government elections. So it's a constant cycle of elections, which we don't have a publicly funded system of politics. It is funded exclusively, almost exclusively by private funding. So trade union money is very, very important in our system. So the question then is really, starting point is, why do trade unions engage in politics? And this, looking for the answer to this, I think you would go to Sidney and Beatrice Webb, who really wrote the very famous book in 1902 about the function of trade unions and trade union activity, and the things that trade unions need to do in order to be effective. And one of the things they identified, they identified three ways in which trade unions operate, three different methods, one of which was basically political activity. And really, trade union political activity in the UK developed from even before the franchise, in the sense that trade unions, the mining unions, for example, would lobby members of Parliament, would take part in parliamentary committees in order to get legislation that would protect their members. When the franchise was extended after 1867, then MPs and unions in some constituencies would organise in order to get their members elected to represent the constituency. So you had trade union members in Parliament to represent trade union interests and working class interests more generally. And then thirdly, from lobbying to representation, we get to government, create a political party. The Labour Party was created in 1900 as an amalgamation of trade unions, socialist societies, and an organisation that was called Independent Labour Party. And indeed, at that time, it wasn't not until 1918 was it possible to be a member of the Labour Party. You could only join the Labour Party indirectly by being a member of one of these constituent organisations. So it was an indirect party, and it still is today a case that the party consists now of individual members since the 1918 constitutional changes, but also it includes organisational members. So when trade unions join the party, they join as trade unions. Trade union members are not members of the Labour Party. They're members of an organisation which is a member of the Labour Party. And that is a very important distinction, I think, because the legal relationship, so far as the union is concerned, is a legal relationship between the union and the party, not between the party and the union member. So it's a very, very important point that we like to emphasise about party structure, because it does affect the way in which party funding laws can be changed. So that is, in a sense, why we engage in political activity. The second question then is, well, what are the problems with this type of arrangement? I mean, problems arose very, very quickly, in the sense there was a legal challenge to this structure in 1907, which ended up in the House of Lords in 1909, in a very famous, one of the great cases of English law, a case called Osborne and the Amalgamated Society of Railway Servants in 1910. And what the House of Lords said is that this structure of the Labour Party, this form of representation, is completely illegal and unlawful. And the way we attack its illegality is through the powers of trade unions. And what the House of Lords said is that trade unions do not have the power to organise themselves politically in the way that trade unions had done through the Labour Party. And what they said was that it's unlawful for trade unions to impose a compulsory levy of their members in order to finance political representation. And it's unlawful for another reason, because in a sense it undermines the constitutional duty of the Member of Parliament to his or her, well, in those days, his constituents. The duty of the Member of Parliament was to represent the constituents as a whole, not to represent the interests of the union, because the union were paying candidates at parliamentary elections who would be union members to represent the union in Parliament, and the condition was, we will pay your election expenses, we will give you a salary, because we had no parliamentary salaries in those days, on the condition that you accept the Labour Party whip and you vote as told by the Labour Party. Well, the House of Lords said this is unconstitutional, in the sense to modern forms of government are unconstitutional. Only a court could come up with that decision. So, but for two reasons. One, the compulsory nature of the levy, the constitutional structure of the party were declared by the House of Lords to be unlawful. So what happened then was, how do we respond? The next question, how do we respond to this challenge? And in 1913, Parliament passed a very important statute, which again has endured to this day in various forms, called the Trade Union Act of 1913. And it was a compromise. It was introduced by the then Liberal government. Liberal Party were then the party of government. They did have some, trying to get some working class support, but they introduced this extraordinary, really, that act of generosity, legislative generosity on the part of the Liberals, that they legislated to reverse the Osborne decision. And what they said was that in this Trade Union Act of 1913 is that if trade unions want to adopt this kind of political activity, then they're going to have political objects. And the only way you can have political objects in your rule book is if you first have a vote of the membership. So you've got to ballot the membership to see if they want to have political objects. The majority of people say that they want to have political objects for the union can then adopt political objects. But if the union adopts political objects, it must then adopt political fund rules, a separate body of rules which become part of the rules of the union. And these rules must say certain things. One is that the political activity of the union, as defined in the statute, this political activity must be funded from a separate political fund. You can't use the general fund of the union to pay for the political activities of the union. You've got to have a separate political fund. That fund has to be funded by a separate levy of the members. So you've got to introduce a political levy to finance your political fund. And every member of the union has the right to opt out of paying the political levy. And anybody who opts out must have a guaranteed right not to be subject to any disability or discrimination because they have opted out of the political levy. And in addition to that, the rules must make clear that if any member of the union feels that these rules have been violated, then that member of the union must have the right to make a complaint to the chief in those days, the chief registrar of friendly societies, who was the regulator of trade unions, so an independent external agency who would then have the power to impose a remedy to resolve the dispute. Now, there were from time to time a number of quite important cases brought to the chief registrar, and that jurisdiction changed in 1976, so the function is now performed by a body called the certification officer, who is now the trade union regulator. I have to say he's not busy doing trade union political fund stuff, but there is a backstop to which these complaints can be taken. So that was the model that was adopted in 1913. It was changed in 1927 by an incoming Tory government, very partisan after the general strike of 1926, looking for reprisals from the trade union movement. So one of the things they did was to change the default rule on political funds. No longer opt out if you don't want to pay, you've got to opt in if you do want to pay. And that clearly affects the number of people who will pay the levy, and it did lead to a significant reduction in the number of people who paid. The law was changed back in 1946 when we had a new Labour government, Clement Attlee, progressive socialist government. In 1946, the law was changed back to the opting out regime. And the question arises, of course, well, why didn't they just scrap this altogether? Why did they continue to live with the Liberal compromise? And the answer, I think, is because everybody liked that compromise. And the Labour Party in particular liked that compromise, because what the Labour Party had were trade unions collecting money into political funds that could only be used to support the Labour Party. Why would the Labour Party get rid of this regime? It was a burden on trade unions, but it was a fantastic benefit for the Labour Party. It was a guaranteed source of income. In a sense, an unintended consequence of the 1913 settlement. So there, the legislation, that system reinstated in 1946. It survived really through until 1984, where we had some tweaks in 1984. The Thatcher government, what are we going to do about trade union political funding? And they did think about reversing back to the 1927 position, so changing back from opting out to opting in. But, we found a document in the National Archives where senior ministers got together to think, well, should we do this? And Thatcher herself said, no, we're not going to do this because, well, the language used, she said it would cause too much anxiety because it would be seen to be a partisan attack on the principal party of opposition. And for Thatcher, even for Thatcher, this was a step too far. So what the Tory government did in 1984 was to say, we're not going to go back to opting out, to opting in. We'll stick with the opting out system. We'll give you that. But you're going to have to refresh the ballot mandate every 10 years. So you're going to have to get a mandate from your members every 10 years for continuing authority to operate your political funds. So the system we now have is really, it's the old 1913 system with the Tory reforms of 1984 built in. That is to say, you've got to have a ballot to operate political fund rules. The ballot has to be refreshed every 10 years. You've got to have political fund rules which allow for require a separate levy for political purposes. Members have the right to opt out. Nobody can be discriminated against, and there is a right to appeal to the certification officer as a result. So that's a fairly stable position which operated, I think, successfully since 1913, subject to that window from 27 to 46. And the question now is how is it going to change? As Nick pointed out, so we've got a trade union bill before Parliament. It's just passed all stages of the House of Commons, now sitting in the House of Lords, waiting to complete its parliamentary journey. And one of the provisions in the bill is a provision attacking the political levy. And the two things that are being done, one is that we're changing the default position so that we're going to move from a situation whereby people who don't want to pay will opt out, as is the current situation. You opt out if you don't want to pay. That's going to be changed to a system whereby if you do want to pay, you've got to opt in. And that's going to have a dramatic effect on the amount of money that trade unions raise for political purposes. So what did I say at the start? We've got, at the moment, we're raising annually about £23 million. I mean, some estimates are that £23 million will drop to about 2.3 million. Partly because it's not just because of the change from opting out to opting in. It's partly also because of the malicious joy which is being taken about the change from opting out to opting in, and the detail in the legislation about how this process is to implement it. So what they're saying is that if you want to opt in, you can opt in, but you're going to have to renew the opt-in every 5 years. And we're talking, what did I say, how many people are currently paying? About 6 million people at the moment, roughly, who are paying the political levy. So the union is going to have to organise every 5 years to get these 6 million people to opt back into paying the political levy. Otherwise, their opt-in will become invalid. And what the legislation says, you can't opt in online. You've got to opt in on writing, and you've got to deliver the opt-in form to the head office of the union or to the local branch office of the union, or send it by post. Now, how many people here last sent a letter by post? Who last bought a stamp to send a letter? And so the whole point of this is actually to discourage people from using this procedure, from actually opting in. So apathy will be compounded by apathy, in the sense that people just won't bother to do. So you can't phone up members and say, do you want to opt in? You can't opt in at the time of recruitment if you're recruited or join the union online. And you can't opt in by email. You've got to do it in writing, by sending or handing the form in at the branch office or the head office of the union. So that just ain't going to happen on a sustainable basis. And the other change, so that, I mean, it's clearly deliberate. So you look at the detail in order to understand the purpose. And the purpose of this is not for the benefit of some trade union member who feels aggrieved because he or she is not able effectively to opt out of the procedure. This has been done really for partisan reasons, which is to undermine, I think, the financial stability of the party of opposition at the present time. It has been, I sense, an ambition of, and we know this just from things that have been said on the public record, an ambition of the front bench of the government, some members of the front bench, to have a go at this. They see this as unfinished business, I think, from the Thatcher period. But that's only part of it. The other thing that's quite funny, really, I think, I mean, certainly if you're a Minister of Law, it's funny, is the changes to the rules relating to the certification officer, because the government is unhappy that not enough trade union members are taking complaints to the certification officer. And that may be because people either don't care or because they're not a problem. So they want to stimulate the number of complaints. So what they're doing in order to stimulate the number of complaints is to say that hereafter members can take complaints to the certification officer if they've got a complaint about political fund rules, but so too can the certification officer. So the certification officer can now bring a complaint to the certification officer about a breach of political fund rules by a trade union. And the certification officer will then sit in judgment of his or her own case, will cross-examine his or her own witnesses, and will then reach a decision in his or her own case, and will impose a penalty, because we've got new financial penalties that we can now impose on trade unions following these decisions. And this applies not just to political fund cases, it will apply to a wide range of other disputes involving trade unions where clearly members don't have an issue and clearly are content with the way in which the organisation is being administered. So it's an extraordinary provision which, we've just put in evidence to our Parliamentary Committee on Human Rights, and it's quite clear that this is a violation of we've got a provision called the Human Rights Act, a document called the European Convention on Human Rights. And part of that is Article 6, which says that everybody shall have the right to a fair trial of his or her civil rights and obligations. Well, these are disputes about the application of legislation and the application of union rules. This is a dispute about civil rights and obligations. You cannot have a judge sitting in judgment of his or her own cause. I mean, it's a clear, egregious violation of these fundamental principles. But again, it's a window into what these people are thinking about when they're drafting this legislation, a window into the purpose of the legislation in question. So that really raises a question for us, and I'm saying for us in the sense the people I work with on the trade union side, is what we're going to do about it. And clearly, there are, you go through the process, the political process, with your eyes open, and they've got a majority, so they can do what they want. So you can protest as much as you like and as loudly as you want, but they're not going to change this, and it's not going to change. So this is going to be enacted, and trade unions will have 3 months post-enactment to get everybody signed up, to get everybody contracted in. Otherwise, existing levy payments will lapse. So 3 months to get 6 million people, 5.9 million people into membership. So the question then really is what we do about it, and really it's just, it raises questions about litigation. And so my sense here is that, look, I mean, I come here and I see, we've been speaking in class about the Union's New South Wales case, which I think was a great victory for the trade unions. And the reason why I look at that case with some enthusiasm and interest is because, not because it's directly equivalent, but there's enough in that case, I think, to interest a court in the UK. The differences are, the similarities are sufficient to make the differences irrelevant. And what comes out from that case, if I was sitting in the court, is just the pungent smell of partisanship. This is using political power for partisan purposes. And the court being turned on or off, depending on how you look at it, but being turned on or off by what is clearly, transparently, an abuse of power by a party of government in relation to his dealing with the principal party of opposition. So I have a look at that and I think, well, that kind of stimulates, there's something there, I think, that's beginning to ring a bell in my head. And then I go to another case that we've been looking at in class called Citizens United. I never ever thought that I'd find this something I could find useful. But this was a case where the US Supreme Court struck down restrictions on the right of corporations to make expenditures in the course of elections. And there's some very, very useful provisions in that decision. And one of the issues in that decision was the government saying, look, it's okay for us to ban corporations from making independent expenditures in elections because we allow corporations to set up these political action committees, which actually are not that dissimilar to the political fund arrangements we have in the United Kingdom. And there's some beautiful rhetoric in that case that we can use because the court is saying, well, that's not good enough because it is still too burdensome to impose this kind of regulatory regime on a trade union consistently with the requirements of the First Amendment of the Constitution, which guarantees the right to free speech. So I'm beginning to think I'm on a roll here. So then I go to the European Convention on Human Rights, and in the Convention it says in Article 11, there is a right to freedom of association, including the right to form and join trade unions for the protection of your interests. And you begin then scratching around with jurisprudence. And this jurisprudence has been very, very slow in the development. And the court has been very, very reluctant to engage with Article 11 because it wasn't a priority. And quite rightly, in the 1970s, this was not a priority issue. But since 2002, the eyelids have lifted, and the European Court of Human Rights has become very, very engaged with Article 11. And one very important case in 2007, which is a case called ASLEF, or Railway Union, ASLEF against the United Kingdom. There's a very important passage. I wish I'd remembered that. I didn't think I was going to talk about this, so I didn't bring it. But from memory, what the court said in the ASLEF case was to emphasise the importance to trade unions of the right to engage in political action. And this was a legitimate activity of trade unions. Now that's important, because what the court is saying in this case, as well as in other cases, and some people think it's a bit of an oxymoron, that trade unions have human rights. And these human rights of trade unions are greater than and different from the human rights of their members. So the union as an entity has human rights, and same with corporations as entities have human rights. That's an even bigger oxymoron. But it is nevertheless the case that trade unions have human rights, and these human rights are being violated in this case. Quite clearly, the right to freedom of association is being violated by these restrictions. And the question then is, and we discussed this in class this morning, well, how do we resolve this problem? Because Article 11, paragraph 1, gives the right to freedom of association, including the right to form and join trade unions. But Article 11.2 says, well, you can have restrictions on freedom of association, provided these restrictions are prescribed by law, which these will be, and provided that they are necessary in a democratic society for the protection of the rights and freedoms of others. So if I'm in government, what am I saying? I'm saying that these restrictions are being introduced for the benefit of others. Well, which others? Who others? Well, trade union members. Okay, but we didn't realize there was a problem, but okay, we were introducing these restrictions for the benefit of others. But you're going to have to convince the court that it's necessary to introduce these restrictions for the benefit of others. And this then comes down to what we discussed in class this morning, this balance of proportionality. Is this a reasonable or proportionate restriction to defend the interests or protect the interests of others? Is this violation of freedom of association a proportionate restriction in the interests of these other people that you're trying to defend? And my sense is that it's not. And the reason why I think it is not a proportionate restriction is first because we already have a regulatory framework in place whereby now trade unions are required to ballot their members every 10 years for authority to continue to operate a political fund. Every member is free to take part in the ballot. If you don't like the ballot result, unusually you have the right to opt out and not to be bound by the result of the majority. So we don't have majority rule. In the sense you already have this protection. You have a right to ballot every 10 years. You don't like the result, you can opt out of the obligation to pay. So in a sense what we've done is we've individualized a collective decision already. And if there's any, not only do we give you the right to opt out, but we give you protection. We give you the right of protection to, in a sense, you can make this complaint to the protection that you can't be discriminated against, and protection in the sense that any mucking around, you can make a complaint to the certification officer. And to say, well, people don't opt out. People do opt out. We've got about 500,000 people who exercise this freedom at a particular time because they care enough to do so. So in a sense, we already have a system of regulation which probably goes further than is required. But secondly, the other issue which arises here is that this new legislation is in clear breach. We don't have a constitution, people tell me, but we do have constitutional conventions. So what now? One of the constitutional conventions is what I've been referring to as the Churchill Convention, which goes back to 1948. And the Churchill Convention is that you do not introduce any change. So this is Winston Churchill, so everybody saw it must be important. So we go back to Winston Churchill, 1948, and he made this statement in the House of Commons: you do not change the rules relating to funding of political parties or the regulation of elections without the consent of all the parties. And that's basically, it's a lock against partisanship in the redesign, reconstruction of party funding rules. And that's very important. And we have followed that, really, as a nation, ever since 1948. The Labour Party, when it came in, massive majority in 1997, completely redesigned party funding laws, but it did so with the clear consent of the Conservative Party and did not take advantage at all of its electoral majority. It could have done whatever it liked in 1997, but it did so. It made big changes, but it did so with the approval and consent of the Conservative Party. And indeed was very, very responsive and respectful of the Conservative Party's interests during that process. Very determined not to do anything that would undermine the structure and organisation of that party. Very sensitive form of intervention. So, in a sense, that is a very big thing for us, in the sense that that convention has been violated. The Labour Party does not support these changes, and even the Scottish National Party is opposed to these changes. There's nothing in it for them, because, in a sense, it would serve their interests, in a sense, for this change to go through, because it would weaken the Labour Party. And in Scotland, of course, the Labour Party has been decimated. The last thing the SNP wants is the revival of Scottish Labour. But to their great credit, the SNP have respected this convention and have said that they are opposed to these changes. And the third reason why I think this is disproportionate is not only do we have an existing body of regulation which goes beyond that of most countries, not only do we have a constitutional convention which has been violated by the conduct of government, but thirdly, we have a system of regulation which for the last, 30, 45 years, attempts have been made by various commissions of inquiry to find abuse, and no one has been able. Everybody wants to find it. Everybody wants to be the first to say, we have found the reason for change. This system is not working. Here's the evidence of abuse. Nobody has found it. We had a Royal Commission, 65 to 68. We had investigation by a Parliamentary Select Committee in 1983. We had an investigation by an Ethics Committee, Committee on Standards in Public Life in 2008, 2009. We had, 1999. And then we had another investigation by the same committee in 2011. Nobody has found any evidence of abuse, and they've said so expressly. The best example I had, it was in 1983. I was advising a parliamentary committee at the time, and I said to this guy came up from the Engineering Employers Federation, and one of their issues was we need to change the political levy back to contracting in. So I passed a question to one of the MPs, and I said to him, ask him if he has any evidence of abuse. So we gave him the question. He said, no, nothing you would recognise as evidence, no. And that has always stuck in my mind. Nothing you would recognise as evidence, no. And but that's the sense. It's very partisan. Nobody has found any evidence that this system is not working. And that goes to the proportionality of the regime that has now been changed. The existing system is regulated, it's working well, and no one has found any evidence, not even any significant, but any evidence of abuse. Anyway, so that is, in a sense, where we are, and I suppose what our next step will be hopefully, to launch some kind of litigation against this legislation. But I'd just like to finish on this point, which is to say that what is happening in the United Kingdom on trade union political funding is by no means isolated. The same trade union political voice is being challenged in various parts of the world. Now, the Royal Commission will no doubt provide a nice opportunity for this government in this country to have a similar go at trade union political voice here. We're having the same thing happen with less justification in the United Kingdom, but we also see the same thing happening in the United States. There's a big case pending before the Supreme Court at the moment called Friedrich and the California Teachers Association, which is about challenging the very foundations of First Amendment protection for trade union political activity in the United States. Now, nobody who had any sense would put money on the unions winning that case in the United States at the present time. So what we see, I think, there is a coordinated campaign going on by right-wing governments throughout the world to have a go, not just at trade union industrial activity, but also at trade union political activity, because I guess it is trade union money which is propping up what is left of social democratic parties in much of the common law world. And that is, in a sense, that is why this is a big issue. It's not just about changing the default rule on opting in or opting out. It's a direct challenge to the nature of our democracies. Thank you very much.
Thank you, Keith, for that very illuminating presentation. And I'm going to suggest that we hold off on questions until we've heard from Joo Chong as well. And remind Joo Chong that we do need to get through proceedings by 2 p.m. So please give us some time for Q&A at the end. It sounds like Joo Chong doesn't need much introduction to most of you, but to be sure, let me just remind you that Joo Chong is an associate professor at the Melbourne Law School. He specialises in the regulation of money in politics, and he is the author of a tremendous book, which I have, Money and Politics, The Democracy We Can't Afford. His research also focuses on the regulation of temporary migrant work, but today he's talking about money in politics. Please make him very welcome, Joo Chong.
Thanks for that, Nick and Keith. I want to do 4 things in this brief commentary. First is really kind of address this question, what do we actually mean by political funds or trade unions? Secondly, is to identify what I see as the key issues arising from this use of these funds, in particular some of the evidence that's been ventilated before the Heydon Royal Commission. Thirdly, talk about the regulatory choices to deal with these issues. And lastly, talk a bit about the way forward, if you like. Now, in terms of the first, what do we mean by political funds or trade unions? Perhaps we can start with a rough distinction between funds that Keith has been focused on, which are basically formal funds set up by trade unions to engage in political campaigns, particularly at the national level or the regional or provincial level. And we can distinguish that between funds that are set up by trade union officials for their particular election campaigns. So, for example, Bill Shorten, when he was National Secretary of the Australian Workers' Union, stood as a federal candidate in 2007 campaign and had a particular campaign funds. But things are not so simple, yeah? Because what we have is the murky middle, if you like, right? What the Heydon Royal Commission characterized as one category called fighting funds and second category called slush funds. And these, as you can gather from the terms of these labels, they're not, if you like, watertight or neither sort of like concise, coherent categories. But an example of what are fighting funds? Fighting funds, an example would be one that's set up by the officials, employees of the Transport Workers Union National and New South Wales branch, where basically levies are paid into this McLean Forum, and sometimes as a condition of the employment contract. And then funds, the McLean Forum in turn would use money for various political purposes, including intervening in other branches of the Transport Workers Union, in other unions, for example, the Health Services Union, but also in the Australian Labor Party. So, for example, in promoting Tony Sheldon, who's the National President of Transport Workers Union's candidacy for a presidential campaign in the ALP. Example of fighting fund. Slush fund. Now, this is where the political purpose mixes with the personal purposes, yeah? So a good example is actually the Industry 2020, which is a company set up by officials of the Australian Workers Union, Bill Shorten's former union, and in particular by Cesar Mellam, who's currently a Victorian ALP parliamentarian. Now, money is raised from various sources, building industry employers, union officials, and various other groups. And the money is then used, and this I'll just read out, just for you to get a sense from the Royal Commission. This is from the interim report of the Royal Commission. The money was used principally to advance the political aspirations of members of the Labour Unity faction of the ALP in Victoria, to which Cesar Mellam belonged. This ultimately benefited Cesar Mellam in that it raised his profile within the ALP and facilitated his subsequent entry into Victorian Parliament. Some of the money raised by Industry 2020 was also used to pay for expensive restaurant meals and luxurious overseas conference travel for Mr. Mellam and other AW officials. Another portion of funds was transferred to facilitate payments to striking workers from other unions. The murky middle, yes? All right? Where political purposes mixed with personal interests and sometimes in a context where, if you like, rather shadowy vehicles are being used. Well, what then are the key issues? Well, I think the first is really about what are the legitimate objects of the union, yeah? And following from that, what constitutes proper use of union office or office of union officials. Third, accountability to union members. Fourth, the question of conflict of interest. The conflict of interest arising firstly from receipts from employers that union is negotiating with in industrial context, and in particular when those contributions are used to advance a personal interest, whether that be a political purpose or whether it be what the Royal Commission described in the case of Industry 2020, expensive restaurant meals and luxurious overseas conferences. Fourth, fairness. Fairness is crucial, right? Fairness in terms of both union elections, but also in terms of state and federal elections. And lastly, if you like, basic requirements of governance, yeah? To deal with clarity of purposes in terms of when organizations are set up, clear and transparent lines of decision making, and proper record keeping. Now, with these 6 issues, what then are the regulatory choices? It seems to me there are 4 choices. First is whether to regulate or not. And this is where the principle that Keith mentioned about freedom of association really comes to the fore. Yeah. Some issues that are particularly controversial when it comes to political funds of trade unions. So for example, the level of union influence within the ALP. That for me, these are important topics, but these are not topics for regulation. Yeah? It seems to me that these are topics to be dealt with by the Labour Party and also by the unions affiliated to the Labour Party. So whether to regulate. But even if we decide to go down the path of regulation, the principle of freedom of association is important. So even if we decide to regulate, and we should decide to regulate in terms of ensuring accountability of union officials to their members, what we must understand is that there are a range of ways in which that broad principle can be implemented. So when we think about the UK context, it seems to me that if we talk about accountability to members for the use of political funds, collective authorization should be sufficient. And it's up to the union itself to decide whether they should have opt-in and opt-out. And Parliament shouldn't be stipulating rules beyond what is basically necessary to actually have this principle obtained. 3 other choices. If you decide to go down the regulatory path, then there's a choice whether you regulate trade union funds through what you call uniform legislation or generic legislation. So do you regulate the political funds of trade unions through the Commonwealth Electoral Act, which applies not just to trade unions and political actors, but across the board? Or do you regulate through union-specific regulation? So for instance, through the Fair Work Resident Organisation Act, which applies specifically to unions. And which choice you take raises the question of whether there's, if you like, justified or unjustified differential treatment. Yeah? And if you go down the path of uniform legislation, another choice to be made, and this is raised quite starkly in terms of the Royal Commission report, is that do you go by way of statute or do you go by way of common law? What is really quite interesting, and I think is a debate that's not been fully had, is the Royal Commission at various important points insists that union officials are subject to fiduciary duties. It insists, firstly in a controversial way, they owe their fiduciary duties to the union itself, but have as recently, in a more controversial way, insisted that the union official, when bargaining, has a fiduciary duty to the union members, which, as we know, is a heterogeneous group. Choice to be made. The final choice, regulatory choice, I would say, is a choice between regulating the organization, the union itself, and the organization set up, and or the union officials. Yeah. And I think different tools are needed in terms of dealing with those particular issues. What then should be some possible ways forward? I think transparency is clearly essential in all the various issues raised. And one modest, perhaps effective thing I'll recommend is that under Section 148B of the Fair Work Resident Organisations Act, there are disclosure obligations imposed upon union officials obligations to disclose what's considered, what the statute refers to as material personal interest. Now, it seems to me one simple thing to do to deal with some of these issues is that when a union official receives contributions from the employer, that should be deemed a material personal interest, which they should disclose, both to the other union officials and to the union members themselves, and in a very timely fashion. Now, another suggestion I'll make is this. Section 190 currently bans the use of union resources in union elections. And there's an Heydon Royal Commission talks about this ambiguity, whether it says union elections for that particular union or does it extend further to other unions. But what I will say is this, why just have a ban applied to the union itself? That ban should also apply to the union officials, which use union resources at the very least for their internal union elections. It seems to me to be a very easy way to actually evade the point and the purpose of Section 190 to basically restrict it to the organization itself. Let me end with this. Many of the issues I mentioned arise from the lack of regulation of funding of candidates in union elections. Yeah? This is something the Royal Commission raised. Is it fair in a way that the TWU is funding one side of those contesting elections for the Health Services Union? Now, we might think it's unfair, and we might think it's also unfair in the context where there's a lot of secrecy about where this amount of money is, where the money is coming from. But here's the rub. These questions of unfairness, these questions of secrecy also attend candidates for federal elections and state elections. So let me leave you this question. Is it fair to apply stringent regulation to the funding of union candidates in union elections while leaving a situation of laissez-faire, an unregulated situation where it comes to elections which are far greater importance, state and federal elections? Thank you.
All right, thank you very much for that, Joo Chong. We now have about 10 minutes for questions. So very keen to hear from you. I might open up with a sort of high-level question, and I guess this goes to the even bigger question of donations to political parties. I was involved in the government that tried to bring in a new tax on the super profits of mining companies, and I saw that proposal defeated as the mining companies spent $20 million in about 10 days trying to defeat it through advertising, and the political opposition, the then Conservatives, immediately came out and said they're opposed to it. Of course, it comes to light, well known, that the mining companies made millions of dollars of donations to the Conservative political party. So I guess I want to ask the question, big companies or CEOs of big companies making decisions to make large donations to business-friendly political parties,
Yeah.
how does that differ from trade union leaders deciding to make contributions to political parties that they perceive as being friendly to unions? And if we're talking today about the regulation of trade union donations to political parties,
Yeah.
could the same analysis equally apply to businesses and their donations to political parties?
Look, I think that's definitely, I mean, this again raises the question of fairness, right? I mean, if we are thinking about regulating only, this is issue that Keith has raised, right? I mean, that one group of political actors, when the same concerns can also apply to different groups of political actors, that's great. Even though there are problems with this particular group of political actors, that seems to be unfair. So, I mean, for one, for years, I've argued that, yes, perhaps there should be mechanisms for internal accountability in terms of political funds or union officials, but as a matter of parity, they should also be applied to corporations, yeah? And it's very interesting to bear in mind that, the Australian Shareholders Association for a long time, perhaps not now, has actually advocated that corporations should not make any political donations, yeah? And their argument is something that was ventilated in the case of Citizens United. They basically said, look, I mean, or something in a way analogous to Osborne in a way. They basically said, look, this is ultra-virus, yeah? Okay? This is, we'll put it this way, it's either corrupt or it's ultra-virus.
Yeah, exactly.
That's right. If you're, If you're doing it for some reason to advance the director's interest, then it's ultra virus. Yeah. Okay. But if you're doing it to actually benefit the shareholder, that means you expect a certain quid pro quo. And then if you expect a certain quid pro quo, that smells a bit like corruption. Yeah.
A very clever argument.
Yeah.
Interested to hear from people in the room. Gentleman at the front here.
My name is Praveen. My question is to Dr. Ewing. You told us that unions having to, the opting in mechanism where completing opt-in forms every 10 years, there's a risk that apathy could see the failure of that system. But wouldn't those wishing to maintain the political purpose of these vehicles overcome that apathy or fight to overcome that apathy?
Yeah, I mean, it's look, it's a hard question, and to which there is no easy or comfortable answer, and it's really a question of who gets the benefit of the burden of apathy in this situation, and you know, however you answer the question, the answer is unpalatable, I think. But so the way I would deal with it, I think, is to say that. It's not. There are two problems with unions face. One, apathetic problems. One is the move from opting out to opting in, but the other is the way by which the law requires the opting in process to take place. And I mean, the work we did between, say, 1927 and 1946, when we had that old system, showed that the effect of the change was very different. It affected different unions in a different way, and to a large extent it depended on how union resources or union funds or fees were collected by the union, and so more face-to-face contact would lead to higher opting-in rates. But this system we've got now, I think, makes it very hard for people. I mean, even people who instinctively would want to do it, in a sense, have got. I mean, it's just made difficult for them, in a sense, in the modern day. So in a sense that how many people will go to the trouble, how many people will take the trouble of buying a stamp, filling in a form, getting the form in the first place, put it in a mailbox. It just won't happen. So in the same way, in the same bill, requires new strike ballot thresholds. So you got a 40% return. 40% turnout for strikes in some sectors. 40% people eligible to vote got to vote in favour of the strike. But again, that's got to be done by a postal system. So in a sense, the ballot paper will be sent to people at home. It will sit on the mantelpiece for weeks and weeks and weeks, and then suddenly, shit, I forgot about that. I should have posted it. And of course, it won't go back. And the fact that you haven't sent it back, I mean, the impact of that will be that we won't get the 40% threshold. So in a sense, there's a very, very subtle psychological measures which are embedded in the legislation, which are designed to ensure that, in a sense, to disrupt the activity of the union by not giving unions choice, by not enabling people to overcome these burdens of apathy or whatever, where they may arise. So, I think there are two issues. I agree. I mean, I feel very uncomfortable about this issue, where the burden of apathy should lie. But I would say on that at the end of the day, you give people a choice. You give them the right to vote. If they don't like the result, they can opt out. I don't see why you then vote and then opt in. I don't see why you have to make two positive decisions in order to support activity which has been supported by the majority. I mean, I don't know of any other system of governance in the world, of any organisation in the world, which would require this. And I mean, it's just not fair. So.
Gentleman in the middle there. Middle of the middle.
Me?
Yep, middle of the middle.
You've got the floor. Use it. Yeah, sure.
I'll put this to the ERRN. It seems from what Keith was saying that fundamentally, and what you're all actually working around, fundamentally, for a democratic political system to work, we need, what came out of Keith's thing, we need support of the party system, which isn't written into our constitution, i.e. we only have a decent election if we've got two active parties putting policy to the people, two or more, obviously more than two is better, but putting policies to the people, and the people actually get those policy conflicts as the reason they vote. And that's been perverted, as you say, by what we call corruption from the right-wing side, with huge amounts of money being thrown at political purposes, straight out of the corporations. And to some extent, the whole union support, monetary support, is a very weak support for Labor Party and other stuff. So, I don't know if I've got a question, but we're in a position here in Victoria, because we do have our own electoral commissions who listen to what you say, to actually implement something along the lines that would make it fair, so that monies that are contributed are somehow known to the people, at least.
Well, I mean, we sort of covered this in class. I mean, in Australia, there are two approaches to this issue of political funding, right? And the approach that prevails at the Commonwealth level and in Victoria is a laissez-faire approach. Yeah. In fact, the Victorian scheme basically piggybacks the Commonwealth scheme, and which has resulted in really lots of funds shrouded in secrecy. I mean, the last few years back, and it's more than it now, more than half of the budget of major parties was shrouded in secrecy. We actually do not know where it comes from. Yeah. Okay. So, but then on the other hand, what you have emerging, as particularly in New South Wales, is a regulated approach with caps on spending, caps on contributions, but also quite significant, substantially higher public funding. Look, it's not up to the VEC to decide whether to enact legislation. It's up to the Victorian Parliament. And I think one of the very corrosive beliefs standing in the way of proper regulation in this area is that, and I think we saw this, expressed in an interview that Gavin Jennings, who's the Special Minister of State, gave, last year or maybe sometime this year, is basically Victorian Parliament seemed to think that they're cut from a different moral cloth from their New South Wales counterpart. Yeah? Their New South Wales, perhaps because of its deeper convict history, is just, this is New South Wales. It's a problem for New South Wales. And I think it's a very corrosive belief. It just beggars belief, really. Yeah.
All right. I'll come to the front, then we'll go back to the middle again.
I was just listening to Keith talk about the tinkering around the edges of the regulation in the UK as compared to this country where there is no regulation. So I'm interested in your observation. If you're having discussions with your counterparts in this country, are you suggesting that they, fight this Trade Union Royal Commission? What you suspect, and clearly going to be some criticism from or some push by the Union Commission and the Trade Union Royal Commission and possibly government. So, would you argue don't regulate or regulate in some way? I'm talking about political, because we don't have the system you have.
Well, look, I think, it comes back to the first question about, say, corporate political donations. And, I think there's a lot of hubris about regulation, in the sense that it's well-intentioned, but it never works. And I think that's the first lesson, that I've learned, is that legislation is rarely effective. It depends, contribution caps in particular are rarely effective. And the reason why, so you want to control corporation political activity, the amount of money that's going on, or maybe you want to control trade union political activity, the amount of money that's going into the system. You won't do it. Look at the United States. They've got very tight contribution caps. But the United States is the most expensive democracy that money can buy. It's extraordinary how much money is actually donated into the system. The reason why contribution caps can't work is because contributions take place in secret and because they can be easily avoided. I think it's just not worth the effort. I think there are other reasons why you shouldn't do it, but I just think as a regulatory tool, it's just not worth the effort because it can't be made to work. If you want to stop corporations from making donations, then the lesson that I've learned is basically the way we did it in 2000, which is to say, we're not going to stop you making donations, guys. But if you do, you've got to make sure you've got shareholder approval. And so you've got to get shareholder approval every 4 years for political donations and expenditures. And you know what? I think you could count on the fingers of one hand the number of public limited companies that make donations to political parties or engage in independent expenditures, because they're not prepared to put these resolutions to shareholder meetings every year or every 4 years. So you get a shareholder, you get a company report every year, and it will tell you we make no political donations. It is not the policy of this company to make political donations, because internally it is too divisive. And that, in a sense, is a better way of dealing with this problem than the elaborate system of regulation and caps and prosecutions, which don't work. I mean, you're never going to convict somebody who has made a large political donation through his or her children or through his or her partner. It's not going to happen. So too many political interests will get in the way of it happening. So you cut it off at the source, and you cut it off on the basis of self-interest. Why are you playing politics with my money, says the shareholder. So,
All right, we are right. It is at 2 o'clock, so I'm going to take this one last question and hope for a rapid-fire response.
I was going to ask, why do you think it's controversial that union officials should have fiduciary duties?
No, it's not controversial they should have fiduciary duties to the union itself. Yeah, and in fact, some of the Act sort of reflects some of the duties. What is controversial is the more recent submissions of the council that union officials, when bargaining, owe fiduciary duties not just to the union but to the union members. Now you might ask, why is that controversial? Because being a fiduciary in terms of law equity is that you basically have this undivided loyalty to your beneficiary. Yes? Okay. Now I represent all of you. Some of you support, and I'm negotiating enterprise agreement, right? You know, and some of you are casual employees, some of you permanent employees, some of you at different levels in terms of particular work, in terms of what you get paid, and so on and so on. Some of you value parental leave. Some of you don't value parental leave and prefer to have a higher wage. Now, how am I going to have undivided loyalty to all your different interests and opinions?
So the Americans have a good doctrine, which is called the duty of fair representation. In a sense, you've got to represent all your members fairly. And if you don't, then there are legal remedies available if that duty is not complied with. That's probably better than a fiduciary duty rooted in the common law, I think, which is unclear. It's not clear. It's unclear whether the duty, as a matter of common law, whether the duty is owed to the members or to the union, if indeed it exists at all. So, and I think the common law cases go back to the 1960s, and the issue is kind of left hanging. And I can't think of a single case actually where the case has been decided on the existence or otherwise of the fiduciary duty. You've got to scratch really, really deeply to find any authority. So it's a difficult issue, and there are better ways to resolve it.
All right, it's been a tremendous discussion. Thank you all for your attention. Please join me in thanking our speakers.